There's been an important decision from the Supreme Court, hasn't there?
Yeah, absolutely. So the Supreme Court gave their judgment in this case called emotional perception AI.
Is that going to make it easier for people to get patents for software?
We get software patents in a sense all the time, where the invention, the new bit, is in software. And there are big classes of things where there's no particular problem with that.
So you're using the software to control it, basically?
Yeah, that's right.
So what actually happened to emotional perceptions application? Did they get their patent?
I do think they've got potentially a clever and significant idea. But my personal opinion, I think they probably will still struggle. If you've got a technical solution to a technical problem, then you should be able to get a patent.
Hello and welcome. I'm Robert Games, Managing Director of Albright IP. Welcome to our podcast, Figure 1, an IP Conversation. Today I'm joined by Freddie Noble. Amongst other things, Freddie has a first-class honours degree in computer science and engineering from Jesus College at Oxford University and leads our patent team in the area of computer science. AI is on the tip of everyone's lips at the moment, although the technology has been in development for a long time. IBM's Deep Blue defeated the chess champion Garry Kasparov in 1997, showing that a supercomputer could beat the chess world champion. Since then, we've come a long way, and everyone has access to an AI search engine. So, Freddie, can I patent a new idea in the field of artificial intelligence?
Well, maybe. It depends what the idea is. And I suppose that's an unhelpful answer. But, why not? Why should there be a problem with protecting a new idea in the field of artificial intelligence? We can protect new mechanical inventions. We can protect new chemical inventions. So why should AI or software more generally be any different? Well, the catch is with software that there is an exclusion in the Patents Act and in the European Patent Convention that says the following things are not inventions. And there's a list of 4 or 5 things actually, but the one that we care about today is a scheme, rule, or method for performing a mental act or doing business or a program for a computer. So that program for a computer exception is obviously highly relevant here.
Sure.
Now, the Act does go on to say that the thing is only excluded, so an invention is only excluded to the extent that it relates to that thing, so a computer program or a business method or whatever, as such. So that certainly seems to leave the door open, but I suppose the question is it wide open or is it ajar? The door is somewhat open to inventions that use computers and use software. And we have had over the years quite a lot of cases. And what I think they've all boiled down to is there a technical effect? So, does the computer software have a technical effect on some technical process?
So we know that patents are for technical inventions, right? But what does that really mean? I mean, everything with computers is technical in a sense, isn't it?
Yeah, that's right. It's all very well me saying, it's patentable if it's a technical invention with a technical effect, but it all depends on what you mean by technical, doesn't it?
Yeah.
And this can be a difficult problem. And it's not just me saying that. There was a case in 2012 called Really Virtual Co. Limited, where the judge said that actually this whole business of whether something's technical is not readily amenable to systematic analysis, is based on an impression given the cases and kind of drawing analogies. And your previously decided cases are never going to be exactly the same as the invention you've got right there in front of you, are they? Because we're always talking about a new invention.
Sure.
So it can be really hard. But nonetheless, actually, there are a lot of, I think, quite clear cases. And we get software patents in a sense all the time, where the invention, the new bit, is in software. And there are big classes of things where there's no particular problem with that. So one example is where you've got some control of a process. It might be a production process, control of a machine, something like that. So you've got an invention in a technical field, which is not the technical field of computers. Say you're controlling a furnace or something like that. You've changed the software in the controller to make it burn more efficiently. Well, really the invention there is in the technical field of running a furnace. So although the old furnace is exactly the same as the new furnace in terms of its hardware, and the only thing you may have changed is the software. Actually, the technical invention there isn't a computer program. It's a way of controlling the furnace, which is implemented in software, as many things nowadays are. So there should be no problem with things like that.
Okay, so that makes sense. If you've invented a better molding machine or production line or furnace or whatever it is, it doesn't really matter that you've implemented the change in the software. The invention is really about the plastics molding or the furnace monitoring, a clearly technical thing.
Yeah, absolutely. There should be no problem with those kind of inventions. And in fact, I think a lot of the time we don't even realize we're writing software patents when in a sense we are. So there should be no problem there. I worked on a stack of cases that were to do with traffic light control, for example. And, this is a problem that everyone's experienced. If you've driven in a busy city, can get quite frustrating, can't it? You sat and there's a red light in front of you and it changes green and 2 or 3 cars go and then it goes red again. And, everyone complains about whichever idiot it was who set the traffic light timings. But in fairness, they're probably not an idiot. It's just that it is quite a difficult problem to get that just right. And, I worked with a client who was doing sort of machine learning to try and build better control algorithms. And of course, all the hardware in those traffic lights are the same. I mean, they've still got a red light bulb, an amber light bulb, and a green light bulb. They've still got the sensors to see who's queuing up. But it's the control system, and they were using machine learning to try and improve that. And there is, new software there, but a technical effect in the real world.
Sure.
Hopefully, better traffic flow through the city.
So these are inventions, sorry, where there's a real world effect, something in the real world that you're actually controlling. So you're using the software to control it, basically.
Absolutely. And that's an invention in a technical field of running a furnace or controlling traffic or whatever. But then that's not the only kind of software invention that you can get. There's another sort of big class of things where there's a kind of internal technical effect, and in a technical effect inside the computer. And I've done, again, myself, a number of applications around the themes of things like backup and recovery software. You want to make your backups, obviously, in case a hard drive or a component in a computer fails. You want to have a backup that you can recover from. There's then a question of, will the backup work? How do you set up recovery, possibly on different hardware? And this is, a problem with the whole business of running computers. And where we've got inventions that solve problems that really span across anything you might do with the computer, it doesn't matter whether you're doing your accounts or playing games or drafting patent applications, whatever you're doing with the computer, it makes it a better computer if backup and recovery is managed better. And so in those sorts of things, we have an example of a kind of internal technical effect. And those don't tend to present a problem either. I've done many of those applications, and we've never had to argue that they're outside the scope of the exclusion because an examiner has simply never raised it.
Sure. So we have a few examples where you shouldn't hit a problem. There are presumably some other areas where there are clearly no technical effects. Inventions which basically have no hope of getting a patent.
Yeah, well, and in fact, according to the Patents Act, they're not inventions under the definition.
Okay.
That might be contentious, actually. But yes, there are some things where there's basically no prospects of success. And we obviously do get a lot of inquiries. People ring us up and say, I've got an idea for a new app. And a new app may be patentable. It depends what it does, because it may have an external or an internal technical effect. But quite a lot of the time, what people have really got is an idea for a new business, a new model for doing business. And of course, a lot of the sort of apps that have really flown are really kind of a new way of doing business. And of course, that's implemented using software, but the software is really doing its ordinary job as application software. It's doing things that are technically routine, and it may well be novel and non-obvious, at least in the sense that the business model or what it's actually doing is new and inventive. But it is going to cut across probably the computer program exclusion, and maybe the business method exclusion as well.
So, Freddie, there's been an important decision from the Supreme Court, hasn't there? Is that going to make it easier for people to get patents for software?
Yeah, absolutely. So the Supreme Court gave their judgment in this case called emotional perception AI. That was just last month. And it is a significant decision for sure. But the effect, I think, in terms of which things are eligible for patent protection and which things aren't, I think could be quite subtle. So what the Supreme Court have said in emotional perception is this test that we've been using effectively for the past 20 years. It's called the Aerotel test after a case that was in the Court of Appeal, 20 years ago now, is wrong. So that test that the courts and the Patent Office have been using, they were going through these 4 steps to try and determine whether something fell within that computer program as such exclusion or not, is no longer applicable. And so that's big news, really, because it's a framework that the examiners at the Patent Office have used in pretty much every case that might cut across this exclusion to work out whether it does for a long time. So that's gone out of the window now. And they've given us an interpretation of the law, which actually isn't a new interpretation at all, because the EPO have been doing it for a long time, and the Supreme Court have kind of said, well, why are we different? The EPO isn't wrong, and we should follow the very logical way that they have set things out. And to cut a reasonably long story short, what this I call it a new test, but it's the EPO's test that they've been doing for a long time. What it says is, well, we look at the claim, and if there's any hardware at all, any technical thing whatsoever in the claim, then the whole invention isn't excluded. So it's much simpler test than this previous 4-step test to apply, and that's where we are now.
That sounds like quite a big change, but presumably that's not the end of the story.
Yeah, so it sounds like a massive change. But I've just said it's going to be quite subtle. So, given that when you look at the claim, if there's any hardware feature at all, it's not excluded as such. Well, why isn't that a massive change? Why isn't that opening the floodgates to protecting everything as long as if you've got a keyboard and a mouse in your claim, it's all right? So the software's new.
Yeah.
But I think the catch is this. We still have to assess novelty and inventive step. And we have to make sure when we're assessing novelty and inventive step that we're making that an assessment on an invention. And remember, the law says that an invention is not a computer program as such. So what we have to do under this new or EPO-inspired test is strip out any bits of the claim that don't contribute to a technical effect. So just because there's a thing in the claim, it doesn't mean that it's relevant to the assessment of novelty and inventive step. We actually have to look at what technical effect the claim has, and then look at only the bits of the claim that contribute to that technical effect in order to work out whether it's novel and inventive. So this difficult question of what is technical is still there. Software features can count as technical sometimes. Hardware features can count as well, but only if they contribute to a technical effect. And in some extreme cases, if you've got no technical effect at all, then you might be stripping out everything in your claim apart from the computer.
Yeah.
Now, that's okay. A computer's not excluded, but of course it's not new either. So I think this is why, although we seem to have a very dramatic change to how these inventions are assessed, I think at least those clear cases that I've talked about will stay probably on the side of the line that they're on. And those cases, certainly where there's a new app that basically implements a new business method, I think they're still going to be rejected. It might be that the heading on the rejection says novelty or inventive step and not patentable subject matter, but you're still not going to get a patent for them.
Sure. A lot of commentators are saying that things will get a bit easier with this new decision. So do you think they're right?
Well, I mean, time will tell, I suppose. I tend more to, well, the effects will be subtle. I don't say non-existent. I say more subtle. I think those clear cases that I've talked about, those clear cases that were on the right side of the line before, they will stay on the right side of the line. And I think those clear cases I told you that were on the wrong side of the line before, I think they will stay on the wrong side of the line. There are, of course, some difficult borderline cases where reasonable attorneys might disagree as to whether they are patentable or not. It might be that emotional perception's actual application might even be an example of one of those difficult borderline cases.
So what actually happened to emotional perception's application? Did they get their patent?
Well, we don't know yet. So what the Supreme Court have said is, well, the Patent Office's rejection was wrong because it was based on this Aerotel test, which we now know is wrong. But they haven't. The Supreme Court haven't reassessed that invention in the light of the test they've now got to follow. They've effectively sent it back to the UK IPO to say, well, now you've got to make the decision again in the right way. Now we've told you what the law means. You need to go and assess that invention against the requirements of the law properly interpreted. So it's back to the IPO, and who knows, it could be appealed again. I don't know, maybe even as far as the Supreme Court. I mean, I've read their claim. I've looked at their application. Funnily enough, I do think it's potentially quite a clever system, and I haven't heard anyone say it's not even novel, which sometimes happens with these cases.
Yeah.
I do think they've got potentially a clever and significant idea, and it's about recommendations on platforms like Spotify, for example. So it could be really commercially valuable. There's a lot of money in getting people to watch and listen to things now, isn't there? So, but my personal opinion, I think they probably will still struggle. And the reason I say that is I think fundamentally what they've developed is probably a different way of organizing information, which the cases both at the EPO and the UK tend to see as not technical. But I mean, I don't know. I can see some arguments on the other side as well. They are, as part of the steps of their method, they're analysing audio files, and there may be some technical character there. But we'll have to see.
Sounds like if you were a betting man, though, you probably put your money on the decision still not ending up in a patent for emotional perception.
I think I would, yes. Although I wouldn't bet with money I can't afford to lose. That's always good advice, anyway. Of course.
So what difference do you think this new decision is really going to make then?
Yeah, so I mean, let's be clear about it. I do think it's a good decision. I agree with it completely.
Okay.
I do say I think the effect is going to be quite subtle potentially, but I think there are some positive points. I think firstly, this new understanding of the law. Again, not new understanding. The EPO have known about it for years, but I think this new to UK courts understanding of the law is perhaps a little bit easier to apply and may make things more predictable. It doesn't remove the difficult question of what is technical, but I think what the Aerotel test was doing is kind of putting a massive distraction in the way of another argument over what was the contribution, and that was making the difficult question of is it technical perhaps harder than it needed to be. So we're still faced with that question, but I think we might just have a pathway that's a little bit easier to apply. I think there's still going to be blurriness at the borderline, but maybe that's got a little bit sharper as a result of getting rid of this Aerotel test. I think, we're still going to get clear cases on one side or the other. I think we're still going to get clients come to us and we sort of scratch our heads and say, well, maybe that's patentable. And we could give it a go. But perhaps it will be a bit easier to understand and explain the risks that are there. So I do think it's positive in those ways. There is already an indication that the UK IPO are perhaps going to stop refusing to search some of these applications so readily. So we used to put applications in, and if the UK IPO thought they were excluded, they quite often refused to carry out a search. That could be quite frustrating. And oddly enough, I'm not really sure that the difference between the Aerotel test and the new sort of any hardware approach, I'm not sure there's any particular logical reason it should change that practice, but I think that practice is changing. We've already, even a month after the decision, seen some indications that practice is changing, and a lot of people are sort of assuming that will change. So that's quite positive. And then I suppose because the analysis is going to move from patentable subject matter as a sort of standalone point to an assessment of inventive step. I suppose some people are thinking, well, novelty and inventive step is our bread and butter. We have to deal with that if we're, doing a mechanical invention about a new kitchen gadget or a toy or whatever. And we have to do that if we're doing a chemical invention or any other type of invention. So it's kind of our bread and butter. There's nothing special anymore. And normally with inventive step, you do get a certain dose of the benefit of the doubt at the application stage. If you can put forward a reasonable sounding argument, the patent office will tend to sort of say, well, okay, I'll take your word for it. It's always open for someone's challenge after grant, of course.
Sure. So if you get over that hurdle of a technical advantage, then you stand a chance of getting home, really.
Yeah, although I do think that, where there's doubt over the technical effect, the UK IPO, I think, are probably still going to be quite robust there. It is a matter of law, I think, whether there's technical effect, and if they don't think there is one, my prediction is that they're going to stick to their guns unless you've got some proper arguments that persuade them.
Sure. So it's all about, just like for all patents, really a technical solution to a technical problem.
Yeah, absolutely. If you've got a technical solution to a technical problem, then you should be able to get a patent. There are still going to be some difficult cases. Those difficult cases will be where the technical effect is controversial, i.e., you can disagree as to whether there's a technical effect or whether the effect counts as technical. But I think there is a bit of a rule of thumb, and again, I've been saying this for years, I don't think emotional perception really changes this. When you're sort of wondering if your effect counts as technical, is to say, well, is a technical person going to be impressed by it? Because, when people talk about their inventions, they often very naturally point to, what advantages is it going to bring, to the end user? What features are we going to sell? What are we going to put in our, billboard adverts for our thing does this that you couldn't do before? And that's all very well because that's what the customer wants at the end of the day. But a feature being particularly useful or doesn't mean it's technical. And I think what you have to look at is would a technical person be impressed by a sort of technical step that you've made? And if the answer to that question is yes, then maybe we're on to something. It is a rule of thumb and not a legal test, but I think it can be quite a valuable one.
No, it sounds good. So if you are a technical person, impressed by a piece of technical software development where there seems to be a technical advantage, it's well worth getting in touch with Freddie and the team to consider whether you may have a patentable invention. Thank you, Freddie, and thank you to our listeners for joining us on Figure 1 and IP Conversation, brought to you today by Albright IP. Thank you.